relatively easy, and the assistant U.S. attorneys are part of this community. And so it was met with a kind of a big yawn in our office. That's great. In terms of, that's great. That's great. We're happy to do that. Very happy that we have a mechanism around the mandatory minimum sentencing. Very hard, as I already alluded, very hard for United States attorneys in deeply red places, where when they were introduced as the United States attorney appointed by President Obama, they were met with boos. I was met with applause when I was introduced that way here. So, you know, required a lot more work by those U.S. attorneys to talk to their assistant U.S. attorneys and talk about what it meant. And I know that Eric Holder's big message was, this gives us discretion. You should be happy about that. We can decide what the right thing to do is, make an individualized assessment. All AUSAs should welcome that kind of approach. So I'll pause there.
And am I remembering correctly that the Holder memo was rescinded by Jeff Sessions in 2017 and then was reinstated by the Biden administration?
Correct. Yeah, 3 months after Jeff Sessions became the Attorney General, he rescinded that. So it didn't exist throughout the Trump administration. It was put back in place by the Biden administration. And so depending on this next election, I expect it to either stay in place as it is today, under Holder and then continuing in the Biden administration, the Garland administration, or it will be completely undone overnight.
So Aramis, you've obviously had a slightly different experience. You've been dealing with the governor, constituents, and also during your tenure, the assistants in the office. So do you have thoughts based on your experiences in Florida, both about how to bring people along like that and you know, how you dealt with the transition from your replacement?
No. I don't, and that's my honest answer. I think we have to be very direct in our approach. In the South, in Florida in particular, it's not about, you know, let's see who can I get on board with me. Let's, you know, kumbaya. The bottom line, they don't want me there in the beginning. So I have to recognize that and move accordingly. I think that it was initially, you know, if you would like it to be amicable. Like, I would love everybody to get in a circle and sing kumbaya, let's change the criminal justice system. But the reality is, you don't want me there. All of the sexual, racial, pejorative comments and criticisms I received, I can't even explain them. You know, I remind people, I received a noose in the mail with a letter that said, die, nigga. Like this was my reality. So just getting past my existence as a woman, as a Black woman in there, excuse me, trying to make change, it was extremely difficult. So I say, when you're trying to make change, you have to recognize your environment. And if you are in one where over time you can get people on your team, then you do slow walk it. If not, you get them straight, grab them by the horns and do what you can do until you are going to be taken out. You know, because if the worst thing is to not do anything when you had a couple of months to do something and you just talked about it. But I commend those who knew what they were up against and said, I'm just going to do what I can while I'm here and I'm going to make change. So that's me, but that's also my personality since I was 10 years old.
So John, you've been in this job somehow for 13 years. Explain.
Well, yeah, I was in Florida. I wouldn't be there. I would have been removed. So you want me to
I being flippant, but no, I mean, you've, something is working in your approach to constituents or people you need buy-in from. And again, yeah, do you have thoughts about how to change norms?
Well, I mean, right now it's harder. You know, before, maybe 10 years ago, we could just do pretty much whatever we wanted. And people would be more accepting of it, I think. But today, there's a culture in this country and in my community that's been awoken to fight back on the things that they may be perceiving to lose, right? And it's a very angry pushback that's happening. You know, the reforms that I talked about, the non-public safety traffic stops and collaborative review process that we initiated, those were two of the biggest controversial things that I have done in office, and I did it during a time where that kind of pushback was at its highest. And I don't know how I survived that. I'm actually kind of surprised I didn't have an opponent in 2022, but maybe I had, you know, been there long enough where I developed maybe a relationship with my community to maybe they just may have accepted that. I don't know, but it's hard to say. All I know is I try to meet my community where they're at, and I recognize that I might be a little bit more left of them, or they just may not understand the criminal legal system and the things that they're doing. So I just kind of having those conversations as much as I can, and trying to engage people. But I think it's a little bit harder right now because people are being told that they have to see things as an either or, and I really think it's an and, that we can do a lot of things that complement things.
So Sasha, from a scholarly perspective, and also from a perspective of somebody who's helped DAs craft policies, I didn't realize we looked at it that way. Do you have thoughts on these shifts, the backlash, changing norms, guidance for reformers?
I have no guidance. But I do think, maybe this is for students, to think about the work that you can do and the help you can provide from where you actually are. So as a scholar and a researcher, there are things that I can do and not be fired or recalled that you can't. And then of course there are things that are, you know, above my pay grade. I can't, I'm not actually on the ground making these policies. And so I think it's really worth asking. So I, like many of the people at this table, have been doing this for over 20 years and watched the cycles, the challenges that Aramis and Melinda are describing come and go in different places and in different ways. And sometimes winning doesn't look like you thought it was gonna look. I will say that this conversation itself would have been impossible 20 years ago. Well, none of us would have had these jobs, but also, but culturally and normatively, we were not in this place to have this conversation. That's a way of winning, even though everybody is still fighting. It is, after all, an adversarial system in more than one way. So I would just encourage people who are interested in this work to understand that there are so many ways. I've done public policy, I've been a public defender, I've been a community organizer, now I'm a professor, maybe I'll have another job someday, you never know. But there are so many ways to contribute to this space, and so this kind of education about what people are fighting on, I just think is valuable.
All right, so if I can stick with you, Sasha, and if we can finally get to misdemeanors, which you've mentioned in passing already, but you know, I think a lot, especially for perhaps the students in the room who haven't read some of the misdemeanor justice literature, which your book is front and center, it can be a little counterintuitive to focus on misdemeanors because they are low level, and so the thought is lower stigma, lower potential penalties. Why would we focus on them? So if you could talk a little bit more about prosecutorial discretion in that context and why it's critical, that'd be great.
Thank you. So the reason I think it's so vital to think about misdemeanors is that so often many of the injustices in our criminal system take place in the least lit, lowest status, least resource places where nobody's watching because nobody thinks it's important, which is why you can have such rampant constitutional law violations, such rampant violations of the kinds of rigorous norms that we've been discussing here today. As I mentioned before, just in terms of numbers, misdemeanors 80% of American criminal dockets, most of what our criminal system does, it's the most common way that Americans will encounter our criminal system. And to appreciate the weight of encountering the American criminal system, even when we call it a petty offense or a minor offense, I think is part of the conversation around mass incarceration. To appreciate that getting arrested is a violent, marking, traumatic experience that, as we know, can even be fatal for so many reasons. We learned that during COVID. That going to jail, even for a brief period of time, can be life-threatening, and even without COVID. Health-threatening, being brought through the criminal system can lead, even when it does not result in a misdemeanor conviction, people will be incarcerated, they may lose their jobs, they'll ruin their credit, they may lose their cars, their housing, they may be rendered homeless. In other words, there's a whole panoply of burdensome, punitive consequences that we visit on people who pass through the misdemeanor system for the most minor forms of conduct. And I say most minor not because there's no such thing as a serious misdemeanor. There are, of course, offenses that we define as misdemeanors that may involve harm or the threat of harm. I'm thinking of DUI or domestic violence. It's that we call them minor and petty. Our system defines them that way, and then we accord fewer resources and we pay less attention. So I think that that's just backwards. I think we should be spending more time thinking about what happens, the burdens, the punishment, the marking that happens to the most people, and that makes up the bulk of the prosecutorial job, because those dockets, of course, occupy the resources of offices, of courts, of jails, and of course, public defender offices. So once we accept that misdemeanors are not minor for the people who sustain them, then we can turn a more critical eye to the processes and the systems that produce them. And I've already mentioned how important I think prosecutorial office policies around thinking about misdemeanors are, and I'm happy to, I hope we can have a conversation about it. I won't belabor the point. I will just mention, I think it's worth mentioning just a couple of specifics. So, and this has to do with the discretion around charging. So one of the things that happens in the misdemeanor space is sometimes people point out that a lot of misdemeanors eventually get dismissed in some jurisdictions. 30–50% of people who are charged with misdemeanors, initially charged with misdemeanors, will not actually sustain a formal conviction, and that's one of the things that is sometimes said to say, well, you know, this isn't really a big deal. People are not getting convicted. I think it's appropriate. Here I am at Berkeley, so I get to cite Malcolm Feely, who famously wrote a book many decades ago called "The Process is the Punishment." The process of going through the misdemeanor system itself is extremely punitive. But I want to double down again on this conversation that we are having about charging, in particular, the difference between policing and prosecution. Because the declination, the decision not to charge a case is not the same as a dismissal. It is a much more powerful decision. It is a much more, I want to say, essentially, it goes to the heart of the prosecutorial role in gatekeeping our adversarial system. And a declination, by definition, and different jurisdictions call it different things, no papering or non-prosecutor. It's not about the vocabulary. The decision that the fact of arrest itself is not enough to support a criminal charge, and thereby declining that case changes the entire pipeline. So jurisdictions that have adopted strong declination policies, strong declination defaults, have prevented the criminalization of thousands of people. They did not become defendants. Their families did not bear that burden. The communities did not suffer that stigma. The jails were not filled with their bodies. The public defender did not have to gear up to represent them. It's just such an enormous opportunity for equity and efficiency. And it's so often missed for reasons both normative, because Many offices, including public defender offices, often do not invest the kinds of resources and attention to misdemeanor dockets that they do to felony dockets. I trained in a misdemeanor docket. I was doing, many, if not all, public defenders, just as junior prosecutors, train in misdemeanor dockets. And I was also very fortunate to work in a federal public defender office that was well resourced and took misdemeanors very seriously. I had a 2-day Daubert hearing in a misdemeanor case. That you cannot do that in most offices. My boss was like, knock yourself out. How many experts do you want? That's a luxury, that's wealth. We don't usually get to treat misdemeanors that way. The reality is many misdemeanors, the misdemeanor dockets are treated as spaces in which it's okay to learn and make mistakes, which is inherently devaluing the liberty and the dignity and the needs of clients if you're a public defender and the needs of defendants if you're a prosecutor. So it's just worth noticing that the whole system that much of the system is structured around institutionally devaluing these decisions across the board. I'd like to take aim at that and rethink those value decisions. And then also noticing that even when people's cases are eventually dismissed and they do not sustain a conviction, there's an enormous amount of punitive harm and burdens that people are sustaining. And notice the gap. So in prosecutor offices where junior prosecutors and Ron Wright and Kay Levine have done really important work in this space, where junior prosecutors are training in misdemeanors, the research indicates that junior prosecutors, before they have learned the ropes, are far more deferential to police, under perhaps professional pressure to rubber stamp because they don't want to be perceived as soft on crime. They also haven't done this a million times. They don't understand that a loitering case or a low-level drug possession case is not serious in the way other cases in the office that the office are handling are more serious. So they tend to have low declination rates for their own, for their own institutional and educational reasons, which means all those cases with all the biases that John and Aramis have been talking about, all those policing biases are passing unfiltered into the adjudicative system. All those individuals are now getting criminal convictions that reflect not a considered equitable prosecutorial decision that this case warrants prosecution, but essentially mirroring the challenges and the biases and the policies of policing. And that's actually not how the criminal system is supposed to work. That is supposed to be a prosecutorial choice, with the exception, of course, of the handful of jurisdictions in this country that still permit police to direct file their charges, which I'm happy to rant about later if anybody wants to hear why I think that's a bad idea. But there's so many costs to skimping on that initial exercise of prosecutorial discretion. And so it's one of the reasons I think it's so worthwhile looking at policies like the ones that Chesa instituted in his office, John, and other offices around the country, to see that it's not a secret how we might do this, that the models are there, the templates are there, and we could shift so much of that criminalizing net away. We could reduce that net so much by focusing on this particular moment in misdemeanors. You just heard descriptions from these experienced prosecutors about the thought that goes in to charging felonies. In the federal system, there are memos upon memo about how prosecutors should think about it. The problem in misdemeanors is that sometimes they're not being thought about at all.
So I want to be mindful of the time because it would be great to leave about 20 minutes for questions, which means that maybe we could have about 4 or 5 minutes of follow-up on what Sasha just said. And I'm just going to add one more follow-up question, if I may, which is, given how many misdemeanors there are and how difficult it would be to exercise individualized declination decisions, especially at that early stage, I'm assuming, but tell me if I'm wrong, that one of the things that you're suggesting is some categorical declination with respect to certain low-level offenses. And if that's the case, what do you say to critics who would say, I'm sorry, but that's a legislative choice, and you are really usurping the role of the legislature if you are just taking a law on the books, unless it's been, clearly abandoned in some way, and just deciding not to enforce it.
So I want to reiterate something that Rachel, not to stop you from getting up, but that Rachel mentioned before, which is we never used to worry about the scope of prosecutorial discretion during sort of the height of the war on drugs and mass incarceration. We just assumed that it was plenary. And it hasn't been until recently when reform-minded prosecutors have started to wield that discretion in different ways that all of a sudden we think that there are constraints on them that somehow we never really thought there were before. So I just think that's such an important point. I will note that the misdemeanor declination policies that I have seen, with some exceptions, but for the most part, are not fairly deemed categorical. So even, so John's memo has an exception section, and yes, I printed it out, for public safety exceptions, which means there is still, it's categorical in the sense that it's a categorical presumption, and all the law students now know the difference between a presumption and a requirement. It's a thumb on the scale. It's entirely consistent with the way we have always thought that prosecutors not just can, but should put their thumbs on the scale for policy reasons. That's why we have holder memos in the first place, because we think it's their role to give guidance to offices, to line attorneys, and to the system. So I think that for the most part, not to take anything away from the enormously important fights that some prosecutors are having about even more categorical declination or dismissal policies, that most misdemeanor declination policies leave some room for discretion and therefore are classic expressions of prosecutorial discretion and deviate not at all from that picture.
So I'd love to hear the thoughts of John, Aramis, and Melinda. And while I say that, just a reminder that we have mics on both sides of the front of the room. So if you can begin to think about what questions you have and even come on down in anticipation of asking them, that would be wonderful. So Melinda, starting with you, I know that petty misdemeanors in the federal system or jury demandable misdemeanors are numerous, but not quite what they are in the state system. But thoughts on either that or categorical declination?
Well, it is interesting to me that all this conversation about categorical declinations and sort of controversy around it, because that's the practical reality. Mm-hmm. That's been happening as long as I've certainly been a lawyer. There are all sorts of categories that we did not focus on as prosecutors and didn't bring cases under. I already mentioned one, illegal reentry. We just didn't prosecute all of those cases. They had to be serious misconduct involving victims and harm to people. Otherwise, we simply didn't do it. And sometimes people were deported again. There are alternatives to the criminal system for people. But I'll in no particular order of importance, I remember John Ashcroft, when he was the Attorney General, was very interested in the U.S. attorneys prosecuting adult obscenity, which by definition didn't involve any non-consensual conduct and didn't involve children or any kind of use of force. I was actually dragged back to Washington, D.C. Each office had to send a representative. Bob Mueller decided I was the representative to go and meet with John Ashcroft about prosecuting adult obscenity. I will tell you, we never did. Mm-hmm. We had a categorical exclusion in San Francisco. because we can pick and choose in the federal system, even in something like an investor fraud case, there was sort of guidelines. We wouldn't prosecute them under a certain dollar amount. That's probably one place that we weren't transparent about it. I would say for the most part we were transparent when we had essentially categorical exclusions. We didn't do it in that context because we didn't want people to think they could steal, a certain amount of money from an elderly victim and not be prosecuted. So we did try to we didn't actually advertise that. But I don't get the controversy over categorical declination policies because that's been going on as long as anybody's been around.
Aramis and John, other thoughts on?
I know you wanted to speak.
Yeah, well, I mean, I think this is a great question. This is the question that I think actually within the prosecution community across America, it also kind of divides us. Because what you lay out there is that if the legislature has passed a law, right, then for another elected official to say, well, I'm just not going to do that, there's a lot of nuance to this, but it's become political. And so this is why it's kind of dangerous right now, because it's in this back and forth about in the politics. I mean, quite frankly, as a part of partisan politics, it's a part of the playbook to get reelected or stay in office. It's a good thing for a governor to say, on the more conservative side, but it's also in blue states. It's happening in blue states as well, where attorney generals and governors are saying this rogue Democratic prosecutor is out of control, right? So I think those categorical declination policies, I think I agree, they've been around forever, right? But they're just being done in a way that it makes, maybe they're more public, it's a part of a movement, and then there's an anti-movement. That's why we're debating this right now. But I actually think it's a good thing, because it just means that more of us in America are starting to pay attention, and the quality of justice in America doesn't get better unless the people realize that they actually own the system, right? And so, I don't know, we're going to get through this somehow. We're going to keep fighting for prosecutorial independence so that we can make these decisions. But I do think that when prosecutors have these blanket policies or categorical things, they should be transparent. But I just think it's a better policy to think about having a presumption type of an approach, or just some exception approach, so that you can then say that I'm not saying, no, I'm never going to do it. I'm just saying that this is like how I'm going to prioritize my resources, what is important for my community, right? I think that's really, really critical. The drug policy that one of my least favorite things to do is my least favorite law are the laws that criminalize drug possession, because I just think there has to be a better approach. And so during the pandemic, I saw the opportunity to say that we would no longer prosecute fifth-degree drug cases, right? And those are the lowest level. In Minnesota, they're pretty much all felonies, except for a small category of gross misdemeanors. But we had a public safety exception, right? And I actually there's a local newspaper article that all my police chiefs said that we understand, right? They didn't say they necessarily approved of it. But then what I realized during this pandemic period was that everything that was wrong in downtown St. Paul about drug use and all of that became my problem. And so now, today, I bet you that policy, if we pulled the numbers, the exception is probably maybe even overtaken the rule. But it's a recognition that when you do something like that, you've got to have some alternatives in place, right? So we're working on building out those alternatives and working with our community. I mean, I think the best thing that we could be doing in America around drug possession is actually, in drug use, is actually recognizing it as a public health issue and convincing our police officers that they actually have discretion. They can actually do something different. Their default doesn't have to be to bring them to jail. The default could be something else. And it would be a return to community and developing out those partnerships. But that's a long conversation. There are concepts of law enforcement assisted diversion. There's, we're doing a lot of work on just, deflecting things back out to the community and having the community solve the problem or whatever the issue might be. But that's, I think, the future of transforming our justice system so that it is a justice system that's actually worthy of its name, to recognize that not everything the default should not be bring it into that procedural system that we subject everybody to, whether it's the misdemeanor or the felony, that that doesn't necessarily produce the best outcome.
Thanks. And again, before we hear Aramis's thoughts, if you have thoughts, just an encouragement, especially to the students in the room, to come on down and start asking questions. We'll have almost 15 minutes left. Aramis?
So I hesitated to speak last because I think it is important to make the distinction between blanket statements on charging and blanket statements on sentencing. And I think that distinction is important, having obviously started a whole nationwide international conversation about the death penalty and sentencing, starting in the state of Florida, because if you have more conservative, right-leaning individuals criticizing the legislative behavior that prosecutors are engaging in with, categorical declinations, that's a separate conversation. I don't agree with it, but that's a separate conversation that I think is resolved by, like what John has said, and I think others mentioned, presumptive policies. But even in that, we have to recognize that those who lean that way, who don't really want prosecutors making any of these decisions and utilizing their discretion, they're still going to find another way around it. So they're like, oh, well, don't announce it. That's fine. They'll go to public records requests and then get what they need from you and still get, their long-term goal. But when we talk about sentencing, I think that it is extremely important to recognize, for example, my decision against the death penalty. We cannot have the conversation as if, that's that was a violation of the law, or they're not following the law by not seeking max penalty. I'm confused because as lawyers, when we say that someone has violated a law, we usually cite a statute. And there's absolutely no statute that, at least in my situation, that I violated. As a matter of fact, criminal procedure in the state of Florida, Rule 3.181 says if a prosecutor chooses not to seek death penalty, the wording is if. So there is no mandatory, and I think we all know what Woodson, all the other cases that say that it is an Eighth Amendment violation for mandatory death penalty. We don't have any laws that require mandatory sentencing except for those that are acknowledged as minimum mandatories. Because of that distinction, it allows us to have, I think, more productive conversations when we meet out the very differences between categorical declinations as well as policies not to seek max penalties.
Thanks. Looks like we have our first question. Jump on in. Not sure that's on.
Hello. Okay, good. Hi, thanks panel. Really enjoyed it. I have 2 questions, if you'll allow me. So my first is for Professor Natapov. So I think I would love to hear you rant about, direct charging, because that's the thing I was thinking of as you were speaking. But maybe a little bit more of a direction for the rant, which is, that a huge direct charging jurisdiction, and maybe the biggest, I'm not sure, I don't know, the whole country is Cook County, right? Chicago does direct charge misdemeanors, and the last time I checked, felony drug possessions, they allow police to direct charge. So, and the last time I checked, they still do, despite the fact that, Kim Foxx has been prosecutor for about 8 years. So I wonder how direct charging might be changed, whether the progressive prosecutors are looking at that as a point where you could leverage change, because I think it is a place where we need to change. And I don't know if her office has done any policies to try and mitigate the damage that's being done by direct charging, particularly in Cook County. But I think it's interesting that oftentimes direct charging by police doesn't necessarily map on politically, but often can be just a function of, well, Chicago is huge, so we're going to let the police charge misdemeanors, for example. So just how it maps onto politics, I guess.
Sure. Thank you for the invitation to rant. So we have experts on Cook County here in the room, so I'm not going to get in, and I am not an expert on their direct charging situation, so I'm not going to try to answer that question on the ground. For those of you, so let me just explain what we're talking about. So there are about a dozen states that by legislature, not by prosecutorial discretion, permit police to act as prosecutor on the cases that they themselves have made an arrest on. And it's almost always for misdemeanors. It's actually a very old practice. It used to, before we had a professional prosecutorial bar, police often prosecuted their own low-level cases, but we didn't have the formal distinctions that we currently have. So it's a little tricky to map it onto the historical trajectory. But the bottom line is that a handful of states still permit police to prosecute their own misdemeanors. So what that means is you might be prosecuted by the state and therefore have to work out a plea bargain with the same person who arrested you. And so the heart of the rant, I think, is that to the extent that we now really rely so heavily on prosecutorial discretion, on prosecutorial charging decisions, on prosecutorial gatekeeping, it's actually backwards to delegate that authority back to the institution that we are relying on prosecutors to screen and to regulate and to check. So that's the problem with direct charging. I think, and I've written about this recently for anyone who's interested in pulling some of the legal threads, but one place one might run into this problem in an interesting way is in immunity doctrine. So as probably most of you know, police receive qualified immunity for their decisions to make an arrest, which means that they can be sued if they act unreasonably under existing law, whereas prosecutors cannot. Prosecutors, of course, have absolute immunity for any charging decisions that they make. So one might ask the question, what happens to the immunity question when a police officer acts as a prosecutor in the case in which they themselves made the arrest? No court, to my knowledge, has spoken to this question. It's an open question whether police might get to take advantage of prosecutorial type immunity. The one, I think Justice Ginsburg had a footnote once that thought that would be ridiculous, but it's not binding. So the idea is that because police do not have the quasi-judicial stature that prosecutors have, theoretically they could be sued for malicious prosecution for the direct files that they engage in case anybody wants to write a student note.
I see Zeke and Daniel, two students with questions, but other thoughts on direct charging? All right. Zeke, you want to jump in?
So thank you for the question. I had an issue with law enforcement when I attempted to deal with some drug. Some of them were misdemeanors, some of them were felonies. And instead of it reducing it, it actually increased it because they were trying to prove a point. So again, it's going to depend on what your jurisdiction's goals are, but I do think it should be and can be, and I imagine he's going to give you some numbers that show where it can be effective.
Yeah, so, I mean, if a prosecutor had a categorical policy on a number of, let's say, low-level misdemeanor offenses that I'm not going to prosecute, or is there some presumption that I wouldn't prosecute in these because I have other more important things to do around violence? That would be like a policy that a prosecutor could have. That's going to have really no impact on the police. It will have an impact on police behavior, but I think it's, well, first of all, the law still exists. So whatever legal justifications that they have to investigate or do whatever they decide to do, they'll do that. Now, what ends up happening, though, is when these policies come into place and then the police know about it, and then they start talking about it, and then there's a good segment of people that don't understand it or don't like it, and then they'll start basically showing up to these situations and maybe pulling back or telling residents that they're not going to do anything about this because the prosecutor won't prosecute these cases. That's happening across all around America, where I think police unions that are at odds with prosecutors who are trying to make these changes about what's important for their office and maybe prioritizing certain things from others. I actually have sensed a pullback and blaming and actually telling the resident they're not going to do anything about the fact that somebody broke into your garage and stole your ladder because the prosecutor isn't going to do anything about it. So there's, I don't know if I'm answering your question, but that's the reality on the ground floor of, in terms of this issue, in terms of how it plays out. But from a legal perspective, the law still is there. I mean, if you steal a ladder, it's still a crime.
I was going to just add to it. I think it becomes a power dynamic. Like I've said it, he does it. Like he's just said it. Like how are we going to get what we want? Prosecutors are like, yeah, I want to avoid that. Sometimes law enforcement may be like, yeah, but I want to, so they can frustrate the system by sharing it with people. They can frustrate the system by surveilling for that particular crime or whatever. So I think that is an issue that's going to have to be ironed out, what the impact is with individual jurisdictions.
So, Kyla, I forgot that you had a second question. Maybe we can get both questions in, and then hear some last thoughts from the panelists.
Thank you. I don't mean to. So my other question was kind of on the other end of the spectrum, which was charging police for use of force up to and including homicide when they're in their course of duties, right? So I know at least in California there's been around 2,000 justified homicides and 4 willful homicides, which is at least from the DOJ data, right? So that's kind of the breakdown. But the interesting thing to me is that from what I've seen, about a little over half of the prosecutors' websites actually publish declination memos for all of those cases. So I think this is a really kind of interesting moment of transparency and accountability that can be perhaps useful, but could also perhaps be misinterpreted as well. Sometimes I've seen in the media, especially more right-wing media, you can kind of say to us, oh, everything was fine, right? And they don't necessarily look at the civil side or look at other issues. So I just, for the prosecutors on the panel and other folks, how do you think about that charging choice, that particular moment of discretion that's very public, and what do you think about declination memos as an approach to that?
And maybe we could get Daniel's question in real quick, and then.
Thank you all for being here. I want to talk a little bit, or ask a question about separation of powers, flesh that out a little bit. I guess one of the ways that I think about the criminal justice system is as a funnel, in that the legislation passes the law enforcement allegedly should narrow in the enforcement of those laws, prosecutors narrow further, judges narrow further from there. It feels like in the past that baseline wasn't working, and this panel that we're having is in part a response to that stasis not working. As a result, now we've got legislatures that are impeaching Larry Krasner. We've got governors that are firing or impeaching officers in Florida. So my question is, what should the separation of powers balance look like? What does the correct flow of cases look like through that system? And I guess, what does the future hold in that space for separation of powers?
And I should also say, it looks like we have 30 seconds left. Apologies to everyone for the fact that this is truncated, even though these are excellent questions. But if folks have short thoughts on either police charging or separation of powers.
Well, I think that the checks and balances that are, like, for instance, if it's police and prosecutor, I believe that they would be in the part of the bucket of enforcement, right? Their job is generally to enforce whatever the legislature would pass. So taking it outside of that, though, I think that the prosecutor has a very important role to check the police, right? As does the judge, could check the prosecutor as well, or the police. But the legislature could also check the enforcement branch if they don't like it. So but it's worked, that whole system, that political system, it's worked for a long time. But until recently, where this has become more heightened, it's a part of partisan playbooks, it's gone off the rails. And hopefully today, you'll hear more about that and think about how we can bring it back to where it needs to be.
Thanks. Other thoughts? Awesome. Well, thanks so much, and thanks to our panelists for being here.